This is Duke University.
Welcome to Duke University's office hours. I'm Forrest Norman. I work in the communications office here at Duke Law School. Office hours is being webcast today from the law school, which is honoring Open Access Week with a day-long workshop on best practices for open access law journals. Today I'm speaking with one of the workshop's principal organizers, Duke Law's Rufty Research Professor and Senior Associate Dean for Information Services, Richard Danner. Professor Danner is going to talk about open access issues and publishing and preserving legal scholarship in the digital age. Professor Danner, who earned his BA in Political Science, his Master's in Library Science, and his JD degree from the University of Wisconsin, has held various positions overseeing the operations of what is now Duke's J. Michael Goodson Law Library for 30 years. Recently, he presided over a major renovation, a physical manifestation of the changes in information technology that are the focus of much of his research and scholarly interest. Under his leadership, Duke Law School became the first in the country to make all the articles published in its law journals, including back issues, freely accessible online in 1998. In addition, Duke's journals explicitly allow article authors to post their articles without restriction on freely accessible third-party websites, as well as on internet sites under their own control. I'd like to start by asking a general question about Open Access Week. Today's event, the workshop, comes at the end of Open Access Week. Can you talk a little bit about the goals of the open access movement and how they affect and overlap the goals of a law school?
Well, I can. Thanks, Forrest. It's nice to be here, and this is Open Access Week, and we're capping it off with a workshop that we'll talk about here at the law school. Open Access Week, I guess, ties in generally to scholars' general interest in making sure that the work that they do, the scholarship that they produce based on their research, is widely accessible to as many people as possible. And open access as a concept, I think, probably began to be talked about and thought about in around the year 2000 or so, perhaps a little bit earlier. Things were going on prior to then that were really open access activities, but I think the name sort of took its place at around that time. The idea then was the pressure that people were feeling because of the high prices of journals that publish scholarship, primarily in the sciences and technology areas and in medicine, that led to a situation where scholarship was being produced at universities, but then the results of that scholarship and the reports of what had been done was then being purchased by university libraries at exorbitant prices, at least from the perspective of the universities. And open access was devised as a way to try to make that information available without those heavy burdens. And so what open access really is meant to be is to, given the availability of the internet, which at that point was increasingly available, is to make scholarship not only available through print means, through the journals, but also via the internet so that anyone who has access to the internet has free and open access to it and can make use of it. Not only as a way to help libraries and others at American universities provide access to that scholarship, but perhaps more importantly, to make it available throughout the world, to places in which the resources to purchase those materials just weren't available. And the increasing accessibility of the internet then was seen as a means through which scholarship could be more broadly available, more openly available. There were a number of conferences that were held in the early 2000s at which principles for open access were stated and agreed to. And those still generally govern what we think about today as open access.
Can you talk a little bit about what the law school has done to move towards complying with those principles?
Well, sure. Our law school has always been associated with public access, open access, and with the public domain, the area in which there are materials that are of importance that are generally available to those who need to use them with use that's not restricted overly by copyright. We have here the Center for the Study of the Public Domain, which is a very active body in terms of promoting access to information. And the law school generally, as you mentioned, has for a long time done what it can to make scholarship produced by the school, by our journals, but also that which is produced by our own faculty, no matter where it's published, generally available. We've had our journals available on our website since 1998 or so, going back to 1996. Even though most of those journals are published in print and are available for print subscription, we have made them available free on the website since that period. And in addition, for our own faculty's publications, for about the last 5 years or so, we have maintained an institutional repository of our faculty's publications, no matter where, as I said, they've been published. That also is freely available on the web. So these things are generally findable on our own website for both things, but also are generally available through search engines. Google Scholar, and such things will also turn up the scholarship that we're talking about here, and it's openly accessible, freely accessible. And the data that we compile suggests that all of these things are heavily used, in the sense not only are they used internationally, which of course is one of the things that we're very concerned about, but we also find that since they are out there on the web, they are, even the older items still have a long shelf life. You know, they're not going to get as many downloads, as many hits as newer things are, but they still are used, which I think shows the importance of this information and how useful that it is.
Well, can you talk a little bit about that? I mean, this information is being used by people. It's of some importance to some people, but can you talk about what the benefits are and some of the differences between being able to access primary legal materials and then the secondary legal materials, this legal scholarship?
Yeah. When you think about legal information, you think about it largely, at least from our perspective, in terms of two types. There's primary legal information, which is the law itself. It's the things that are issued by bodies that have the authority to make law. Legislatures, courts, administrative agencies, these are the things that are there in the books that we have to abide by to go about our business. But it's clearly the case that, given the fact that we have so many lawyers, so many people who are training to be lawyers, in order to understand how the law itself is going to apply to you as you go about your daily business, you need to have some idea of what that law means, how a statute has been interpreted in court, what was intended by the language in the statute itself. And for that to work, you not only have to have access to primary source material, which has become increasingly available for free on the web, on the internet, but it also is necessary to have access to explanatory materials, to comments, to legal scholarship. And so, since most of those things are produced in the U.S. at any rate, in law schools, what we're trying to do is to make sure that information, as well as the primary source material, is available so someone who needs to find out how the law is going to apply to them not only can find the text of the law themselves, but can also find some explanation of how it works, how it's going to apply, and what they can expect to be the case.
Is there a benefit other than the sort of pragmatic benefit that you just described, where the legal scholarship helps people understand the laws and how they might be used, how to interpret them? Is there a benefit to having this discourse made public, where people, one idea might spark another idea? There might be some innovation based
Sure.
in being able to layer these sorts of things.
Well, certainly there is, and one of the things that characterizes legal scholarship, I think, is that the things that are written in our journals or by our faculty are not written for, or are not only of use to other scholars, to other law professors, maybe other faculty in different parts of the academy, but they are written in order to influence policy, to influence the development of legislation, and also to influence courts when courts make decisions on appeal. And there's been a debate for years and years in law as to whether or not the courts actually pay much attention to what's written in the law journals, whether or not legal scholarship has any impact. And it appears that it does. There's a recent study that's fairly comprehensive in its coverage of the federal courts of appeal, which suggests that there is an increasing use of legal scholarship by those courts in their decisions. They're citing to law review articles, they're citing to law journal pieces. And presumably the reason that has happened over the last 10 years or so is because these things are much more accessible both through commercial providers electronically, but also through open access mechanisms. And so I think that we can assume fairly safely that as legal scholarship becomes more readily available, it will have more influence on legal policy making and on the decisions that courts make.
Theoretically, this all makes an awful lot of sense, but when you start getting into the specifics of making publications like law school journals electronic or electronic only, you have to start thinking about how that's actually going to work, what the format is going to be, what the business model is going to be. That is why these people have been brought together today for this workshop. Can you talk a little bit about the genesis of the workshop and the kinds of ideas that are being discussed today?
Yeah. I think it's an interesting thing because what we have, as in many other areas, you have groups of people who spend most of their time talking about issues, but generally talk about them with each other. And, our scholarly communication system in law is fairly unusual compared to that in other disciplines, in that our journals are mostly published institutionally at law schools rather than by societies, rather than by professional organizations or commercial publishers. They're published by the law schools themselves. They're also unusual in that they are not peer-reviewed, as in other fields, but they're edited and the articles are selected by students. Law students are in school for 3 years. Their first year, they have no involvement with journals. During their second year, they're working on journals. In their third year, they may rise to positions of influence and decision-making. Then they graduate. And so consequently, it's unusual in the sense that it's very hard to maintain much continuity. It's very hard to move forward and do something different than what your predecessors did. But those are the folks, students, who basically choose what's published, publish the journals, make sure that whatever is going to be done with them is done so that they are accessible. In addition to that, you've got the law schools, which fund the journals. Generally, most law journals aren't published to make a profit. They're available for very low costs. And there are different interests for law schools than there are, I think, for other publishers as well, simply because of that. Readership is made up, as I've said, of law professors and by legal decision makers. And there are other people who are involved in republishing this information, making it available electronically, sometimes in print form, in packages that are available for sale in different ways. And where we are now, I think, is that as all of these groups' perspectives on legal scholarship is declining, not declining, but is changing as the media change, as the forms and formats change, as journals move away from simply publishing articles to publishing more interactive pieces, discussion pieces, things that people can participate in. Where we are now is at a position where we have to figure out just how this is going to evolve into the future. So the benefit of this workshop is that what we've tried to do is to bring together law review editors. We've got about 30 law review editors from students from schools throughout the country. We have over 30 schools represented overall by editors, faculty, staff, librarians, and others. And we have a number of these people who are involved in publishing or otherwise making legal information available. So it's an unusual opportunity for all of these groups to sit down together and talk about the future of legal scholarship. And we've had several presentations this morning which have presented some of the issues that are involved in that. And this afternoon, our program is designed so that there will be much more discussion among these groups. And we'll see what happens after that and where we go from here.
You were one of 12 law library directors to write and sign on to the Durham Statement on open access to legal scholarship last year, which is one of the seeds for this workshop. What objectives did that statement outline?
Well, what the Durham Statement did was to look at the enterprise of law journal publishing. And it basically called for two things. One was for law journals to move to open access publication, basically meaning that one way or the other, for all journals to make sure that what they published, the articles that they came out with, were all available for free following open access protocols on the website of the law school itself. The second thing that the Durham Statement called for, which was more controversial, was to end print publication of law journals. That in connection with going to open access, which you can do, you can publish things electronically for free without stopping print publication and subscriptions, that you do that anyway. Given the fact that our sense is that in law, legal scholarship, while widely read by law professors, students, and by others, is not normally read in the journal issue itself. Most of these papers are available in pre-publication formats beforehand that are available electronically. Many articles are available one way or another in electronic form, and it is unlikely that most of the people who read this scholarship actually read it in the journal form itself. At the same time, you know, higher education, law schools, as well as everybody else, are under budgetary pressures because of the economic situation. This affects law libraries. Law libraries are the primary subscribers to, purchasers of, law journals. And a way to save money in library purchases is by no longer having to buy, process, and then bind and preserve journals that are probably not really being read in that format anyway. And so the idea behind the Durham Statement, in addition to promoting open access, was to sort of get beyond the myth that the print version of the journal still had the prime place that it might have at some previous time. That means that we all have to work together to make sure that electronically published journals are accessible and also, perhaps more importantly, are preserved into the future. That's the role that libraries and print have always provided, is that the libraries buy the journals, they keep them, and then we know that information is always going to be there. It's a lot different situation when you're dealing with electronic information because you have to make sure that it is being archived and preserved somewhere. You run into all sorts of issues with whether or not today's electronic formatting is going to evolve into the future, so it's still going to be accessible. So those are all sorts of issues that have to be resolved, but it is essential probably for us now to be thinking in terms of those terms as opposed to holding on to print simply because it's a preservation medium.
What, I mean, I know there's another side to this argument. Can you sum it up? That's probably not fair to the pro-print people to ask you to sum it up, but.
Well, you know, I think everybody likes print. I mean, I'm a librarian, so I obviously like print as well. And I think one of the things that we're most proud of in the Duke Law Library and the Goodson Law Library is our collection of print journals. This is the scholarship of law, and it's there on the shelves of the library. It goes back forever, and you know it's there. So there is that. There is also, you know, the general feeling, not only among faculty in law, researchers and others, that there is something to be said for having a print version of the work that you do. Everybody likes to get that journal that comes in that shows finally you've got a final authoritative version. You can put it on your shelf. There it is. And it also carries through more than you might expect it to students, to the student editors. So remember, these are the people who are actually doing the journals, who are putting them out. And while, you know, it may well be that they are certainly much less wedded to print than some of the rest of us are, that, you know, we're getting to the point now where people who come into law school have been using the internet all of their lives practically. They've been using Google and search engines. They're impatient with print tools and print resources generally. Once they get to law school, they develop a fondness for the print law journal. And again, I think it's some of those same things. It gives the sense of there being a permanent record of what you've done. It's nice to have it. It's nice to hold it. And it's good to know that it's going to be there in that format in perpetuity, we hope. So all of those things, I think, are very real concerns. But the reality still is that whether you be a student, whether you be a faculty member, whether you be a judge on the Supreme Court, you are justice on the Supreme Court, you are probably not reading that scholarship in that issue that comes out every few months. You're reading it in some other way. You're finding it somewhere electronically, and if you don't want to read it on screen, which probably none of us do much of, you're going to print it out and use it that way. You're not holding that artifact that package in your hands anymore when you actually read it.
Well, that discussion about the second part of the Durham Statement is going to be ongoing, I assume. But in the meantime, whether or not they're eliminating print, journal editors in law schools are moving into electronic publishing. And this is where the specifics matter, like you discussed. One of the things that's been talked about at the workshop today is just the format that you're going to put it in. Some formats allow you to do certain things that you can't do in other formats. Can you talk about some of the specifics of that, mainly the concern about PDF dumping grounds?
Well, what's happened in law with law journals is that while the primary law journals published at law schools are these days still published in print, but they're available on the websites of the journal. But mainly what you get there, and what has been the case as long as this has been going on, is that you get PDF versions of the articles. Basically just straight PDF, flat PDFs, which means that if you want to download and print the article, it's fairly easy to do, and you get it. It looks just like what you would have if you had it in the book yourself. And that all contributes, I think, to being a good thing for making the articles available. But we don't know that much about how PDFs are going to be preserved into the future, preservable, whether or not we're going to be able to move them into other formats. And they also don't do everything, I think, that you can do with an electronic publication. It's analogous, I think, to the situation with ebooks, which basically have tried, as they've been developed so far, no matter what your reader is, to present something that looks like the book itself. You press a button and you see a page turn. And law journal publication is not unlike that in the sense that as long as we're using PDF, we're not doing as much as we could to sort of make the presentation richer, to provide more the data behind the statement that's being made. Video, if that's appropriate to whatever the subject is going to be. These things are harder to do than if you're working with something that is less based on trying to mimic the print. And it also has to do with searchability, because what we found as people have tried to look at PDFs as they're available on law school websites, a lot of these things are just not searchable by full text, they're not indexed, they're not as findable as they might be. Other formats that would provide metadata and other terminology and make that available when you're doing your searches on Google or whatever search engines you're trying to use will make this material much more accessible and probably also has the possibility of making it more preservable.
We'll close with a question that was emailed to us by a professor at Duke Sanford School of Public Policy. He asks, my question is about the economics of open access journals and lessons from law journals that might inform the sustainability of such a publication model in other fields. Are there some features of how law journals are staffed, how their journal articles are submitted and peer-reviewed, and how they're affiliated with academic institutions that have made it easier or harder to sustain the open access model, and what lessons might be generalizable or not to other fields of scholarship?
Well, as I've suggested, the legal publishing model is different from that in other disciplines. Our journals are student edited. They're not peer reviewed, so the expenses of staff are much less. There's a variety of models, as we learned this morning when we had some student editors from around the country talking about their business models. There's a variety of models that law schools and journals employ in order to publish what they publish. Nearly all law reviews lose money. Their institutions subvent the costs of producing them in order to provide educational experiences for their students, in order to promote publication of scholarship, and to accomplish other things. So the fact that they lose money is not the primary concern of the law schools that publish them. At least it has not been until now. So it's a different animal than I think it is in other fields, because we have these sort of built-in cost-saving devices. We don't charge much for subscriptions to law reviews. We've never been in that position that started the open access movement, where the subscription costs were so high that universities were balking at having to pay them. Our journals are very low cost. Their main subscribers are other law schools, and so it's almost, in many ways, it's a gift economy, with a little bit of money passing passing back and forth here and there. Those things, I think, make it easier in many ways for law schools to move toward open access models of publication because we publish the scholarship ourselves. We can make these decisions if we want to. It's a lot harder to do that in other disciplines simply because of the way that the scholarship is published.
That'll conclude office hours for today. Thank you for joining us, Professor Danner, and good luck with the rest of the workshop.
Thanks a lot.
Produced by Duke University. Online at duke.edu.